Thank you very much for your time. We are back in the office of the Deputy Attorney General, and we have followed him from court. He's doing some work here. The big stories that we're going to ask him about is the big announcement that came last week about the removal of Adom-Otchere, the former Electoral Commissioner, from office. Was it a removal by the President because it occasioned press conference from the opposition? Was it, as some of the lawyers say, that the President was merely a conveyor belt? Well, that matter may be settled in the Supreme Court because popular journalist Kweku Baku Jr. and his lawyer Samson Ladi are in court, in the Supreme Court, challenging the decisions of the committee that was set up by the Chief Justice pursuant to Article 146 of the Constitution. They are in fact also challenging the Chief Justice's prima facie decision that Mrs. Otchere and the two others have questions to answer. So that's going to be a big deal. Will that end up in the Supreme Court? Will that change anything? Is the government preparing to announce a new electoral commissioner? On what basis are they able to do that? Does the Constitution allow the President, within the circumstances, to announce a new electoral commissioner? That's a question we put into the Attorney General, Deputy Attorney General as well. Also, for all Ghanaian football lovers, the World Cup is just ending right now. The Black Stars were not at the World Cup, but there's even more crisis for Ghana football than the Black Stars not being at the World Cup. Football Association President Adom-Otchere has had to resign on the revelations made by the announced number 12 documentary that has been showed across the nation and also been showed by the BBC, the British Broadcasting Corporation. So there's been a court action where the Attorney General has now succeeded in getting the courts to agree with her that the GFA ought to be dissolved. If you dissolve the Ghana Football Association, what happens? How long will the dissolution take? We know that the liquidation of some companies takes up to 2 years. Within the period, the company cannot do business. Who is going to do the business of the Premier League, the First Division, the Second Division, the African Cup? The Black Stars have to prepare for the next African Cup of Nations. The Black Stars have to prepare for the World Cup. Will there be a new Ghana Football Federation, as we're hearing? And also, tonight, we're talking to him about the Alfred Woyome case. Is it dead? Is it gone? What's the latest? Deputy Attorney General, thank you very much for your time.
Thank you very much.
You seem to be enjoying your work as a lawyer. You're still as a lawyer, isn't it?
Yes, yes.
Some lawyer ministers or ministers who are lawyers are in other positions, and right, they don't engage with the law anymore. Do you feel lucky that you're a lawyer and you're still doing the law?
Yeah, I think so. I think essentially it's very much in line with what I trained to be, much in line with what I aspired all my life to be. So it's pretty much enjoyable. Very hectic, but we've always enjoyed the hectic nature of the legal profession, the stress and whatever you. It's something that we cannot do without. So it's a part of our life.
Walk us through the Article 146 process. So a petition goes to the President. They say he doesn't even have to look at it.
Yes, yes.
He sends it to somewhere, and then he waits, and it comes, and he just reads what they have done.
Yes.
But this is the President of Ghana elected by secret ballot, by the majority of the people. Tell us, how does the process work?
I think it's part of an architecture that has been carefully built up to ensure that there's as much as possible least of executive interference with that process. And also, it also pertains to note that certain classes of public officers, the removal of them has been more or less casting the nature of a quasi-judicial exercise. Now, number one is the Superior Court justices themselves. Their removal clearly has to be in the nature of judicial proceedings or quasi-judicial proceedings. And we all know fundamentally that the executive is not supposed to vote or exercise any judicial functions whatsoever. So with that philosophy, any form of adjudication, especially insofar as it relates to the removal of a judge or the removal of a person whose removal has in itself been thrust on the lines of removal of a justice of the Superior Court, is supposed to be exercised in strict accordance with the tenets of those requirements. So Article 146 requires that for the removal of a justice of the judicial, justice of the Superior Court of Judicature to occur, one, there must be a petition by any person at all in the country. It could be a citizen or a foreigner. Once the person is resident in the jurisdiction of Ghana, that person can apply or petition for the removal of a justice. And that petition must be grounded on either stated misbehavior, incompetence, or inability to perform the functions of office. Inability could be either physical inability or mental inability. So the petition is filed, it states your grounds, misbehavior, incompetence, or inability to perform the functions, whether physically or mentally. That petition is handed to the president in the case of a justice of a Superior Court of Judicature. And the president, on receipt of the petition, has no role at all to play but to convey it straight to the Chief Justice.
Must the president make a determination whether
no.
the stated grounds of misbehavior, that the provisions of Article 146 has been complied with
Nope.
by the petitioner?
Nope.
The president not ought to make any determination?
Has no capacity at all whatsoever to make a determination, to ascertain whether it meets any standard. Because to do so would be to vest him with some form of discretion.
So if the president doesn't forward the petition, has he violated 146?
I should think so.
He has.
And an action can be brought to compel him to discharge his constitutional functions of conveying the petition to the Chief Justice. So that petition is forwarded to the Chief Justice. Chief Justice, upon receipt, will then make that kind of determination you alluded to. So the Chief Justice is the one clothed with the power to determine whether the petition discloses a case for the person to answer, that the person against the petition has been brought to answer. And that's what we call prima facie determination.
So one more question on the president. So if the president receives 100 petitions, 100 times he has to forward them to the Chief Justice?
In my view, so. Because to do so will then put him within the role of an adjudicator. That's a person to determine whether on the face of it there's merit or not. And I'm saying he has no capacity whatsoever to make any determination as to whether the petition is meritorious or not. So he merely transmits it to the Chief Justice. The Chief Justice will then make that determination. That's a prima facie determination. Determination as well as a prima facie case. Prima facie case means on the face of it, is there a case for the person against whom the complaint is brought to answer? And of course, the Chief Justice, already trained judicially and knowing what within the circumstances is expected, will make that determination reasonably and fairly. And you see, the Constitution itself is silent on what constitutes stated misbehavior. It's also silent on what constitutes inability to perform functions.
So it leaves that to the Chief Justice?
It leaves that to the Chief Justice.
That's a wide discretionary
and the point is that the Constitution cannot set out in essential fine detail, what ought to be the standard in every case at all. Otherwise, we'll be reducing the Constitution to a simple regulation or an act of Parliament. The Constitution is supposed to set out the broad principles within which the organs of government function and how they interact with each other. So, if the Constitution says stated misbehavior, then the Chief Justice applying her judicial training will then make that kind of determination as to whether, well, maybe just failure to attend court one day will constitute stated misbehavior. Clearly it will not, but that would be unreasonable. So in the determination or in the assessment of whether this prima facie case made against the respondents to answer, the Chief Justice is enjoined to act reasonably in accord with the standards of fairness and what have you. And when that determination has been made by her, if it is positive, that yes, a prima facie case has been established against the respondent or the would-be respondent to the petition, she then will constitute a committee. But it's also very important to know that even the constitution of the committee itself, the Chief Justice's power is limited. The Chief Justice only has the power to appoint 2 persons who are not lawyers and who are not members of Parliament, and who are also, not members of the Council of State, to be on the committee.
2 persons who are not lawyers?
Who are lawyers, who are not members of Parliament, not members of the
So
Council
all
of State.
lawyers are disqualified from that?
Yes, yes, from that too.
Okay.
And then there are 3 justices of the Superior Court of Judicature who also get to feature on that committee. And those 3 justices are not appointed by the Chief Justice.
Who appoints them?
The Judicial Council.
So the Chief Justice will tell Judicial Council that I have made a prima facie case. You need to select 3 of judges of the Superior Court of Judicature
to serve on this,
the High Court, the Court of
committee
Appeal,
of
and the Supreme Court.
Yes.
To serve on the committee. The Judicial Council will nominate the 3.
Will nominate the 3 persons.
Chief Justice appoints 2 people.
Chief Justice appoints 2 persons who are not lawyers, who are not members of Parliament, who are not members.
Where's he going to find them from?
Oh, I mean, I think,
So
well, I don't know, because
if she appoints her brother or her former colleague or something,
that will be on reasonable exercise of discretion.
Can somebody challenge that?
Definitely.
On what basis would you challenge
under
that?
Articles 23 and 296. Because every person...
296 being the application of discretion?
Discretion. And
that it ought not be capricious?
It ought not be capricious, must be reasonable. And then 23 also sets out the standards for reasonableness in accordance with law and equity and that kind of thing. So these are the two major articles of the Constitution which regulates the exercise of administrative
okay. So
functions.
When the panel is complete, what happens?
So when the panel is complete, the panel sets out to conduct its work. And the conduct of its work, there is no intervention, no interference, no rule that can be played by a third party. They sit in camera.
In camera?
Sit in camera.
Okay.
So as far as I'm concerned, we were not even aware of all these proceedings. I was not aware when the committee set out to do its work. The Attorney General was not aware when the committee set out and even concluded its work. I was actually outside the country with the Attorney General when we all got to know that such a report in this particular case that we alluded earlier on to had come out.
Do the people, who are on trial, so to speak, quote and unquote, do they have the right to counsel in their hearings?
Yes, they do have the right to legal representation. Okay. Indeed, in any administrative proceedings.
Is that cross-examination from one lawyer to the other?
Absolutely. They are accorded all the full rights.
So they sit like a court? And
indeed, let me even disclose one material file that I got to know later on. You know, earlier on you said the matters that we're going to address in this interview will be the Woyome
as well,
proceedings.
Yes.
The Woyome proceeding, the last time I went to court was in January. So February, I applied by way of hearing notice. At the end of January, we went to court. Early February, around 8th February or so, I applied for a hearing notice to be issued on all the parties for us to continue the business. The registrar of the court said, oh, I should hold on. Of course, he's a court manager. Up to March, I should hold on. And I compelled him to give me an explanation. It was at that point that he told me that it is because the presiding judge was also participating in the proceedings for the removal of the EC chairperson. Okay. That is why...
So you were not aware of who was on the panel?
I was not aware of who was the panel. I was not even aware that is why no date would be given to us in the Woyome case. Because apparently the sessions were so hectic. They were sitting every day, day to day, Monday to Friday, and therefore the judge clearly was incapacitated to also sit on our proceedings. So that tells you that those proceedings are very elaborate, very comprehensive. The parties affected are given all the full rights of a party to civil proceedings. And I think that is even more than a civil proceeding. Because the Woyome case, we have even been to court not more than about 8 times. But in this matter, if indeed sittings were held on daily basis, and the sittings commenced around January, February, and they terminated only about 2-3 weeks ago. You can imagine the volume of work that was produced there. So really the proceedings by the Chief Justice Committee set up under Article 146 are so elaborate, comprehensive, and have called to all parties the full rights that they can exercise at common law. Now, so when the committee concludes its work, it comes out with this report in which recommendations are made. The recommendations could be an affirmation of the petition and consequently an order by the committee or a recommendation by the committee for the removal of the justice or the public officer concerned. Or it could be maybe a request, a directive, by the committee for a suspension of the officer concerned, or that the petition itself is dismissed. So, I see. With that happening, the Chief Justice who receives the report forwards it to the President. The Chief Justice at that point also has no discretion whatsoever. So forwards it to the President, and the President is also enjoined by Article 146, Clause 9 of the Constitution to act on the report. The Constitution says the President shall act on the recommendations of the committee. So I think that the more appropriate description of what happens is what you said, that the President is just a conveyor belt, because when the process terminates, the President receives a report and then acts accordingly in accordance with the report of the committee.
So there's one that he should remove somebody.
Yes. They have to. If they don't make the recommendation, then there cannot be any removal. For the president does not have the discretion, cannot exercise in discretion whatsoever in these circumstances.
So who does the president inform about this? Is it the petitioners?
About the removal?
Is it the affected persons? Yes.
Who does the president inform about the
who does
decision?
the president inform about the recommendation? When he gets the recommendations as president, he gets the recommendations.
Yes.
It was based on a petition that was brought by a citizen. Does he inform the citizen that your petition is completed and Mrs. Charlotte says position has been recommended as to be terminated?
Oh.
Does he tell the petitioners?
No, I do not think so.
Who does he tell?
I think he will tell the affected person.
Okay.
The person affected will have to be informed of the outcome, and that this is the recommendation in the scheme of Article 146. I have no discretion at all, and therefore it will be removed, and the decision, to the extent that it affects the public, will be communicated to the public. And I think in this situation, that's
not a very easy job for the president, is it?
Not at all. So in the case of the Chief Justice,
inform all the people? So in the case there are 3 people here. There are 3 people.
Yes,
Charlotte was saying 2 others.
Yes, precisely.
He will inform all of them.
Yes, precisely. Okay. And then also, one worthy point to make in relation to Article 146 proceedings. It can also affect the Chief Justice herself or himself. So a petition can be brought against the Chief Justice, and that petition will be addressed to the President. The President will consult the Council of State to make a prima facie determination.
Or in the
so
case
in
of
the case
the
of
Council of State does.
The prima facie determination is made by the President in consultation with the Council of State.
So here the President has a role to play.
Yes, the President has
the prima facie.
Yes, because the Chief Justice cannot make her own prima facie determination.
Okay, but so that's complicated. You said before when we were talking about a petition to remove the Electoral Commissioner that the Chief Justice will apply her legal skills to make the determination.
Yes.
And value the documents,
yes.
whether stated misbehavior. If you have a president who's an engineer and you have a Council of State that doesn't have a lawyer,
yes.
and that has quantity surveyors
yes.
and doctors and architects,
yes.
And you put them together to make a prima facie determination.
How do they go about it?
Yes. Can they seek the advice of the Attorney General?
Totally. There is jurisprudence on that matter. The case of Adom-Otchere versus the Attorney General, decided by the Supreme Court of Ghana, has made pronouncement to that effect, that the Council of State, together with the President, are entitled to consult their own lawyer, including even a private legal practitioner of their own.
Was that the matter of Justice Akwa, the case that you cited?
No, I think Adom-Otchere related to Chief Justice.
Okay, it was Brighter Kwite who was who wanted the removal of CJ Akwa.
Yes.
Okay. So, I see, that's interesting. So in that case, they can consult lawyers.
They can consult lawyers. I believe that since the Attorney General is the principal legal advisor, they can consult the Attorney General. But the Supreme Court has also given the President and the Council of State the opportunity to even consult private counsel.
I see.
Yes.
Okay. That's quite well understood. So now, the President has gone ahead to do that, and the public have been told that Mrs. Alosose and her 2 deputies cease to be chairperson of the Electoral Commission and 2 others, and the first deputy and 2 deputies. So they are gone.
Yes.
Okay. So will the President appoint, the Constitution allows him to appoint another one?
Yes, definitely. But before I answer the question, I think that's also important to add the matter of interest. I think that the public has been informed that even in these proceedings, all the affected parties were actually petitioning for the removal of each other.
Yeah.
So indeed, when Mrs. Charlotte Osei appeared before the committee of inquiry to give evidence, she actually asked that her deputies be removed from office.
And vice versa.
And her deputies also repeated a similar allegation against her. They also made a similar prayer that Mrs. Charlotte Osei be removed from office, and stating the same grounds. Mrs. Charlotte Osei was arguing that they had failed to live up to the standards expected of them, that they had misconducted themselves and therefore misbehaved, and for that matter, they ought to be removed from office. The deputy chairpersons were also saying that their boss had also misconducted herself. So clearly, I think that the light of all of this...
So when the President met them when the President met Mrs. Salotose, for instance, after the event to inform her,
yes,
the President was speaking to both an accused person and a petitioner in one person. The Mrs. Salotose was a petitioner against...
Yes, I do not know about a meeting, but I know about information.
Yeah,
so the President was informing the person...
Giving them the information, however it happened, he was speaking to one who was, in one sense,
yes.
a petitioner,
yes.
and in another sense, an affected party.
Affected party.
And
yes.
one against whom a petition had been made.
Had been lodged.
So that she would be interested in her petition's success, which was successful, and she would learn that the petition against her was also successful.
And that's a very important point, because you cannot have
that's an irony of
very, very serious that a commission, the members of the commission, the chairperson, together with the deputy chairpersons, all felt that they were both, each other, were unfit to hold office. The chairpersons felt that Mr. Adom-Otchere was unfit to hold office. Mr. Adom-Otchere also felt that the deputy chairpersons were also unfit to hold office, and they should be removed. Indeed, that is exactly what the committee found. So, and it's so clear. So when the committee's report was handed to the president had no discretion whatsoever to exercise, had no role at all to play, apart from merely acting on the recommendations, which is to announce to the public that Mr. Adom-Otchere had been removed. The president might have stated it as if he was the one removing Mr. Adom-Otchere, but the committee's report was what he was acting on.
I see. Okay, let's come to other matters. Now, after the publication, there's been a division among lawyers as to whether this was properly done or not. The consequence of the argument is leading us to a certain two views. Now, some lawyers think that the Constitution gave basis upon which an electoral commissioner can be removed.
Right.
One of them is not a procurement flaw. One of them is not to say that she had violated procurement regulations, because that can be cured. And to the extent that it can be cured, it ought not to serve as a basis for the removal of an electoral commissioner who is such an important figure in the whole democratic enterprise. What's your view on that?
Ridiculous. That's ridiculous. Ridiculous in the sense that a breach of the Procurement Act constitutes an offense.
Criminal offense.
Criminal offense, Section 92 of the Public Procurement Act. Makes a violation of every provision of the Procurement Act an offense. And penalty for it is a maximum 5 years in prison. So the question you have to ask yourself is, if an act, the commission of which can land you in jail for maximum 5 years, is not enough to constitute misbehavior in a public office, then what then else is? If I commit a breach of Public Procurement Act in my capacity as a public officer here, I can go to jail. But when I commit that offense, it shouldn't be capable of removing me from office. Then what then else can?
Okay, so the argument you're making is
what I'm saying is that
the violation of the public
is a criminal offense.
The criminal offense that can take one to prison for 5 years, for 2 years.
And can disqualify you from holding public office.
For holding future public office.
Because it's an offense involving, it's a financial crime, essentially.
Yeah, of sorts, yeah.
And unless 10 years have elapsed, under Article 93 of the Constitution, Article 94 of the Constitution, you are barred from holding public office. So if that act can prevent you, can land you in jail and prevent you from holding public office subsequently, how can you say, or how can you contend reasonably that that act is not enough to ground an allegation of misbehavior against you, for which you can be removed from office?
Yes. I think that you're suggesting to us something more, more dangerous. You are saying now that this office can begin public prosecution of the 3 persons who were removed for procurement violations.
Well, I'm saying that, yes, if you breach Public Procurement Act, any provision of the Public Procurement Act, it constitutes an offense. This office has prosecutorial powers, does it not? And therefore can exercise the discretion and power to prosecute any person at all alleged to be in violation of the Public Procurement Act.
But now you have a writ that has been filed against you by...
And I'm also saying again that indeed when that offense is established against a person in a court of law, the person will go to jail for 5 years. So how can such an act not be sufficient to ground an allegation of stated misbehavior as set out in Article 146 of the Constitution? I think in all of this, you must be reasonable and very objective and fair. I'm not saying that indeed the petition against Mr. Adom-Otchere held merit. That is within the purview of the Article 146 committee, and that committee exercises discretion, exercises powers. They had the opportunity of deliberating on it for about 5-6 months. They even spoke to witnesses that I might even not have heard of or seen. And clearly, when people want to criticize their work, they ought to exercise more circumspection and more objectivity by looking at the necessary consequences of the matters that were alleged Mrs. Adom-Otchere had committed.
Kweku Baako and Samson Ladi are now on your tails. It surprised a lot of people that Mr. Baako would take up the action, but of course those who know him also know his tenacity to his views. He holds very strong views in public matters and strong views in politics as well. And he is a human rights champion and you know, an avatar of the truth, etc., etc. He's thinking that the government may have done something wrong, and he's going to court and he's challenging, first of all, the basis on which the Chief Justice arrived at the prima facie conclusion. Secondly, he's challenging the committee's work. He thinks that it's only a court of competent jurisdiction that should be able to make the recommendations of the removal. That's a germane matter of his suit, that the committee is not clothed with powers to make a recommendation for the removal of the Chief Justice. That if they do, that recommendation can be challenged by a court of competent jurisdiction. It will mean that the court will have to evaluate the evidence and come to a conclusion that this evidence should lead us to this conclusion. What Kweku Baako is trying to do is to test that principle.
That's under Article 296 Clause C, Paragraph C.
Absolutely.
Yes, that's an article that I have had the opportunity of taking to the Supreme Court myself. Article 296 Paragraph C, or the subject matter of the Ransford France versus Adom-Otchere Electoral Commission suit. That I argued in 2012. The Supreme Court ruled against me that indeed it is not every case that the person who is not a judicial authority have to publish regulations to govern the exercise of discretion. In that case, the Electoral Commission, the same Electoral Commission. You see,
what had happened in that case? What is the facts of that case?
Yeah, because the Electoral Commission was proceeding to create 45 new constituencies without setting out the modalities or the manner in which they intended to exercise their discretion under the Constitution. And I felt that that was an absurd and unreasonable exercise of discretion. Justice Ateba told us that it will lead to nuclear meltdown if Article 296 Paragraph C were construed in the manner in which I advocated before the court, and that it is not in every case that the person who is not a judicial body ought to comply with Article 296 Clause C. So I will not comment further on the merits of the action by Mr. Kweku Baako. It's safe to say that Ransford France has very much dealt with the issues, the subject matter of his case to the court. So we'll meet him at the appropriate time. You say he's a human rights advocate. Many human rights advocates have been to a Supreme Court and lost.
Yes,
but
he's
even the president himself,
invoking
nobody can be
the fairness of it. He's invoking the fairness of the process. That's what Kweku Baako is invoking. He's invoking the fairness of the process, invoking the court's right to make a fair judgment and look at the accused person fairly, so that perhaps they are thinking that they haven't looked at the evidence of what happened.
They ought not to have come to that conclusion.
Yeah, the evidence that was given to them, they ought not to have reached that conclusion if they had considered all the evidence. And the grapevine is awash with information about documents that were presented that the committee ignored, etc.
No, that is really not the nature of the action that he has filed, because he's filed an action in the Supreme Court, and he knows that he cannot argue the merits.
To re-argue. He's looking for an interpretation.
Interpretation of certain relevant constitutional provisions. And the main constitutional provision he's seeking an interpretation of is Article 296. But he cannot say that the committee ought not reasonably have come to that conclusion. To do so would then be the nature of an appeal.
Yes.
And this decision, I do not know how you can appeal against it.
Does an appeal lie, though, from a process under Article 146?
Well, I should think that it's rather an application for certiorari, an application for judicial review of the decision of a Superior Court of Judicature to quash the decision of such a committee. And the relevant Superior Court of Judicature in this case will be the High Court, in my view. It's the High Court which can, because the Committee of Inquiry is not a Superior Court. It could have been considered of justices of the Superior Court, in this case Supreme Court and Court of Appeal. But the committee itself is an inferior tribunal. It's an inferior tribunal because in the judicial architecture, it ranks lower than the High Court. Its status is at best that of a Circuit Court, which is an inferior tribunal. And therefore, if you seek to question the reasonableness or an excess of jurisdiction on the part of that constitutional inferior tribunal, your first port of call ought to be the High Court. So if you're talking about an appeal from the decision or findings of such a committee, I don't know about an appeal, but I know about proceedings in judicial review to quash such a ruling. So indeed, the question that will come up fundamentally in those cases, whether indeed the Supreme Court jurisdiction had been properly invoked. I will not comment further on the matter. It's pending before the Supreme Court, and I've made observation that
yes, there's another suit though. Kubaku is not the only suit.
Yes, there's
a more popular one, but there's another suit that you may have to deal with eventually. So that's quite a bit of work for you. Should the president feel himself inhibited from proceeding to appoint a new electoral commission and other deputies, given the circumstances of the challenges that have been lodged at the courts? I
do not see any constraint whatsoever. And the Supreme Court of Ghana has had ample opportunity to pronounce on what a public officer, public authority can do in such a circumstance. And one fundamental principle is that the courts are slow to restraining the exercise of a constitutional power. So in principle, the courts of Ghana will encourage the exercise of a constitutional power. And I think in this situation, there's every imperative for the exercise of such a constitutional power, because you have an electoral commission which has various functions to perform, has a number of elections to prepare for, number of elections to conduct, and it's not conduct of elections is not an event. It's a process that commences with, a lot of indoor measures and mechanisms put in place by the EC before they actually engage the process of voter registration and that kind of thing. So if an electoral commission is, with all respect, devoid of the necessary composition in a manner as this, it's not a situation that the people of Ghana should want to see at all. And I think the people of Ghana, as well as every person in the courts of Ghana, should be interested in ensuring that the vacancies that have been filled, that have occurred, will be filled in no time.
Have you advised the president to appoint a new electoral commissioner?
I think in the interest of the nation, in the interest of ensuring that there is no unnecessary hiccup or hold back to the operations of the EC, and to the extent that there is no impediment, legal impediment in his way from appointing a new chairperson of the Electoral Commission, yes, the president can go ahead and appoint a chairperson of the Electoral Commission together with 2 deputy chairpersons.
Is he going to do it?
My view is that in the absence of any legal impediment, yes, he ought to do it. And indeed, I'm sure he will do it.
When will he do it?
Very soon, pretty soon. Going to do that pretty soon.
Okay.
The next few days.
Soon?
Very imminent.
Let's talk about the Ghana Football Association.
Right.
So now you have what you were looking for.
Yes.
The order to, dissolve and liquidate.
Not to dissolve.
To liquidate.
Yes, not to liquidate. It's part of the process of liquidation.
So you have begun the process of liquidation.
Yes.
So the Ghana Football Association as it is cannot conduct business within this period.
No, they cannot at all.
So what happens? Are we going to have a new Ghana Football Association?
I think first and foremost, I would state some background to all of this. Myself, I've been very much part of the Ghana Football Association. Many people do not know. For about 8 years or so, I was on the disciplinary committee of the Ghana Football Association. I was the chairperson of the Regional Football Association disciplinary committee for 1 or 2 years. Then I became the vice chairman of the Ghana Football Association National Disciplinary Committee. And I acted in that capacity for about 6 years. I was also a member of the elections committee, part of the committee which held elections for Mr. Kwesi Antechi. I was also a member of the legal committee of the GFA and all. So I'm very much associated with the Ghana Football Association committee. But I think that there's always a time for a person to stand up for what is right, and in this circumstance, the president is doing so. We're all following the call for the president, on the part of the president, for us to ensure that the illegality and, if you may say, criminality that the association had become associated with is put to a stop. In the past few years, the Ghana Football Association has had a very bad reputation. The reputation has been on a steep decline. We all witnessed what happened in 2014 when they went to Brazil. There was that debacle, and consequently, there was a commission of inquiry set up under the Constitution to probe. The report unearthed various facts of illegality, criminality, and misconduct on the part of the GFA officials. Sums to the tune of over $3.5 million could not be accounted for. It's part of the Commission's report. Consequently, there was a white paper issued. That white paper did not touch on those aspects, the use of over $3.5 million unlawfully or unjustifiably by the GFA. And indeed, the GFA itself is actually in court trying to purge itself of those findings. It's in the court for appeal. Mr. Adom-Otchere himself also has some adverse findings against him. He's also in the court for appeal, seeking to purge himself of those adverse findings. So clearly, beyond doubt, the Ghana Football Association had become an emblem of scandal. It's a fact. Then, recently, we saw this evidence. This evidence by Anas Harimia, Anas number 12, sorry, various officials at every level were engaged in wrongdoing, ranged from executive committee members. 5 of them were caught in all this act of bribery, match fixing, and whatever. The regional chairmen of the various regional football associations also engaged in various acts of misconduct. The referees, they are not directors or officers of the GFA, but indeed they are officials who are very central to the performance of the GFA's functions. The GFA cannot carry out any functions without the participation of their referees, match commissions, and whatever. About 90 referees and match officials were neck deep. Bribery, top matches, across the folk, versus Asante Kotoko, here and there. I remember that when I was on this committee, I even had occasion to actually disqualify Asante Kotoko because they had played a match under some violations of certain rules, and I deducted some points from them. Somehow, some people sat on the matter and ruled and restored the Asante Kotoko's point. But as far as I do not condone any illegality at all. I did what was, in my view, right at that time by deducting points from Asante Kotoko and that kind of thing. It became very controversial. So you find an association whose officers, directors, and members, because Adom-Otchere, who was caught in all this, is also a member. When I say a member, I mean on the records of the company's registry as a subscriber. So all forms of illegality were committed by all categories of officers, directors, and whatever. So clearly, it's very correct for us to say that that association had become a symbol of scandal. In such circumstances, the president felt that clearly you cannot continue operating in this manner, and it is proper for us to wind up the company. Winding up means we're going to dissolve it in accordance with law, and it's also important to know that we did not just go on a kangaroo basis by shutting down the FA and announcing dissolution. The president's announcement was that steps will be taken to dissolve the Ghana Football Association, and those steps clearly were steps in accord with law. So the Attorney General was empowered under the law, Section 4 of the Bodies Corporate Official Liquidation Act, Act 180, to proceed to court, because that provision empowers the Attorney General to do so where a company is being used for illegal purposes. There is always a confusion, and lawyers are saying that the objects of the FA have not been shown to be unlawful. That's not what we are saying. We're not saying the objects of the FA have been shown to be unlawful. We're saying that the company is being used for illegal purposes. And that is so much significantly different from saying that the objects of the company are unlawful. And that's the point that's always missing. Indeed, that's the argument that we use in court. And
so
that's
what next then for the GFA?
So now that we've started the process, yes, the law also permits the Attorney General to apply for interlocutory measures, because it would definitely be prejudicial and unfair to the interests of the nation for the association to be allowed to continue in the manner as if nothing is happening. So the court has given the appropriate orders, bringing to a halt all the powers of the executive committee and appointing the official liquidator in the person of the registrar of companies. The role of the official liquidator is to ensure a preservation of the assets of the company. Essentially, they're supposed to ensure that independency of these liquidation proceedings, nothing happens to prejudice or affect negatively the outcome of the proceedings. It's also to ensure that the members, directors, officials of the company are disabled from disposing of the assets and do anything which will not be proper at all. So now, yes, football is going on, and I think that there's a distinction that ought to be drawn between an enforcement of the laws of Ghana and the administration of football. The government of Ghana is not interested in managing football at all. The government of Ghana is not interested in administering football in Ghana. It's always interested in ensuring that the laws of Ghana are respected. The laws of Ghana enjoin that where a company has been set up in a certain manner, that company abides with the laws of Ghana. That is to act in a very disciplined and ethical way and all. So Ghana government is interested in ensuring that there are reforms to football administration.
So Mr. Senator, are you going to form, should we form a new football association? Should I go and register a new football association and encourage Has and Kotoko to join me?
Well, you have a freedom of association, no doubt. The Constitution guarantees freedom of association. If you want to form one, is entirely your right. But I'm saying that all the reforms that we hope to embark on will result in the creation of an association which vests the power into the hands of the clubs. We want the clubs to be fully seized with the processes of managing football, their football leagues and whatever. Indeed, that is what pertains in England. There's an FA, no doubt, but the FA does not fully manage the league. The league is run by a body autonomous of the FA. And in fact, it's run by a corporation, and all the various clubs who form the Premier League have a vote in that corporation. And even the acquisition of property, it must be done with the consent of 2/3 of the clubs. I want to arrive at such a situation where the clubs manage the league, the clubs are in full control of their processes and all. And I think that even this situation where the GFA finds itself in, whereby the president and the vice, the president appoints the vice, it's incongruous. The president choosing the vice, how possible? It's totally undemocratic.
Doesn't the president choose the vice in a national election? He does.
No, I mean the president will go into the election with his running mates, and the people of Ghana, having had a reasonable opportunity to assess the team, will then vote for the president. And they know that they are voting for a president who will be backed by this very competent vice president, Dr. Mahamudu Bawumia.
or any other vice president, any other running mate for that matter. Okay, I get the point.
Well, they rejected another person because of his vice.
But do we run the risk of having, if I go to form a football association, Ghana Football Federation, and then Mr. X goes to form an association, Ghana Football Enterprise, and Connect Stones goes there with Goldfields, and I have Has and Kotoko.
I mean, it cannot happen because FIFA, the World Football Governing Body, will recognize only one association from a country. So there's only one member association that will be recognized from Ghana. And I think in all of this, that's why the government has always been engaging with the clubs. It's very important that we all form. I think the people of Ghana, just like FIFA, are interested in ensuring that football is managed in a very clean way, devoid of any perception of corruption and criminality. Indeed, FIFA itself, when they came to Ghana, the first 2 points in the decisions made was that FIFA does not take any objection whatsoever to Ghana enforcing domestic laws, and that FIFA also has zero tolerance for corruption and illegality. And I think the people of Ghana also have the same. It's in our constitution and that kind of thing. So it's very important for the clubs, as we have always sought to do, to cooperate with us and to ensure that we all move together in a very united front. This is just a very short transition, a period that we're going through just to clean up the system. And it's very important that we do that. Ghana has always had moments of, if you like, a few revolutions here and there whereby the house is cleaned and eventually a very stable democracy it was set up. I'm alluding recently to the June 4, 1981 revolution. Since then, after all that period that we went through, Ghana has had a very period of stable democracy and all. And I believe that after this process have been gone through under the leadership of His Excellency the President Nana Addo Akufo-Addo, indeed we'll find a new football system in Ghana, a system which is very strong, which is very respected across the world. I think in Ghana, Africa, so far Kenya has had that reputation. Now they have a very clean football system. And it's respected.
Does the subsidiary, if I can call them so, subsidiaries of the GFA also go through liquidation, the Premier League board?
The clubs.
No, the Premier League board and the GALCA, who were sort of, that's why I call them subsidiaries of the GFA. What happens to them?
Well, GALCA is independent. GALCA is an association of the clubs. The clubs have their own legal personality on their own. As a folk is a company limited by liability. I think Adom-Otchere is also same. They all have the manner in which they were incorporated. And then they have this loose association called GALCA. And the GALCA are members of GFA. But even the GFA, the membership, it's the individual clubs who are there. But I've seen that, and that has to be distinguished from the membership in the company's records. That is only 5 persons. Kwesi Antechi, Isaac Ado, Nana Benin, and others, Georgia Fiye, and whatever. These are the people who have formed the GFA on record. So when people say that, oh, the members of the GFA, it actually, legally speaking, it's these 5 record.
I think they took it on emergency committee members. Is that not what is reflected in the membership? Well,
I don't know how those 5 persons became incorporated, featured on the documents of incorporation of the company. But those 5 persons are the ones on the company's records as members. But I'm saying that, indeed, so this is something that really has to be looked at. And I'm saying that there's a need for us to have a corporation which actually manages the Premier League, just as we have in England. And that corporation is managed fully by the clubs. And the government of Ghana intends to arrive at that situation, whereby the clubs fully own the process. They regulate what or how the affairs ought to be, especially with the playing of football itself.
How does the Black Stars, who's going to manage the Black Stars?
The Black Stars will be managed by the FA. So every FA, the English FA, actually the one which manages the national team. Yes. But now it's very important that FIFA itself, in recognition of the noble efforts that we're making, has not banned Ghana. FIFA has not banned Ghana because FIFA recognizes that what we are doing is really much in accord with law. Just fully thrown their weight behind us, and for now they've appointed a liaison team, a 2-member liaison team made up of Dr. Kofi Amwa, who was chosen by the president, and Coach Oti Akintin. So they are the ones now ensuring that football goes on in Ghana. And for now, they have ensured that the women's national team trains. They started training for a tournament. The under-20 men's team have also started training for a tournament. Adriana Stars is going to play in the CAF tournament. They also started training. So really, there's nothing on hold in Ghana. And I think that
the league is on hold, isn't it?
The league was put on hold by the GFA itself.
Okay.
It wasn't the government of Ghana which put the league on hold.
So the league being on hold has nothing to do with number 12.
I think it was in the as a consequence to the airing of number 12. Then the GFA itself passed a resolution putting the league on hold. So it wasn't the government of Ghana which took any decision at all to put the league on hold. And now, going forward, the FIFA has also indicated clearly their intention of appointing what they call a normalization committee. Normalization committee is a body which will take care of matters in the interim once every country is going through such crisis or phases in the life of the FA. So that normalization committee will be tasked with a review of the statutes of the FA to ensure that it's in compliance with the laws of the country as well as FIFA's own expectations, and also ensuring that all the powers of the executive committee are exercised by the normalization committee and all. And only they have a lifespan of about 1 year and all. So we seek to arrive at that point, and eventually we'll see something very good for Ghana soccer. And this for the situation where we couldn't qualify for the World Cup will not occur again.
We will qualify for the next World Cup.
Definitely we will do so. And I'm sure we'll win the next Africa Cup next year.
When is Alfred Woyome coming to court?
Thursday, 19th July. We're going back to court this week because, as I indicated, the proceedings were put on hold because the presiding judge was the one also seized with the conduct of the EC probe. I didn't know at all, so I actually petitioned the Chief Justice formally by a letter under my hand, asking her to assign the case to a different judge. And then lo and behold, the following day, the EC probe came to an end and the report came out. So that even confirms that the government had nothing to do with the EC probe. We're even in the dark as what was happening.
Okay. So we'll see you in court on Thursday. And,
sure.
And thank you. Thank you
very much.
It's a pleasure.
Right.
That was
the
Honorable Godfred, the Deputy Attorney General.